Hi guys.
Welcome to the rundown. My name is Yuko.
And I am Mihala Barasa.
Yes, so on the rundown, we cover topics to do with legal issues, regulatory compliance issues. So us as individuals, for corporates, things like that. We also talk about economic issues because, well, we're in Kenya, so economic issues are a big deal for us. And also we talk about other life matters that probably you may find interesting. So remember to subscribe.
Hapa chini.
Yes. So welcome to today's episode. Today we are going to talk about employment laws. Yes. And this episode, we have our resident advocate of the High Court of Kenya.
Huyo ni mimi, by the way, just in case you're wondering. That's me here. Please continue introducing me. Thank you.
And today I'm just going to be learning with you guys. Tutakuwa hapa nikichukua notes. On the employment laws in Kenya. What does it mean for you as employees? For companies. What do the employment laws provide for companies and for individuals?
Okay.
So let's start. Let's start simply. Okay. What's the regulatory framework or the legal framework that provides for employment?
Okay, so maybe we start with the Constitution and the right to fair labor practices. Then we have the Employment Act, which is actually the biggest statute or the mother statute that carries all employment laws. Then we have the General Wages Regulation Order. This one has like a few other regulations that follow an act called the Labor Institutions Act. And then there's the Labor Relations Act. Then there's something that used to be called the Industrial Court Act. The Industrial Court is now what is called the Employment and Labor Relations Court, which is a branch of the High Court of Kenya that hears exclusively cases to do with employers and employees. So off the top of my head, that's what I can come up with. I think when you look at it wholesomely, we have international labor laws.
Yeah.
And when you start from that point of international labor laws, then you start from international labor laws, which is really like a soft law in Kenya because you don't have quite the method of enforcing it. Most of what is in the international labor laws is then now enshrined in the Constitution, in the Employment Act, in the Labor Relations Act, in the Labor Institutions Act. So maybe if I can start from the international labor laws, there are four rights that fundamentally come out, and probably we'll discuss this in a later episode that I will tell you about. Yeah. But there are four fundamental things that always come up. So there's the right to fair labor practices, which is in the Constitution. There is freedom from slavery and forced labor. There is protection from child labor. And the fourth one, I forget the fourth one, but it must be something to do with fair wage. Yeah. So from the International Labor Organization laws and regulations then stems the Employment Act, which is the parent act that we are mostly going to discuss today.
Yeah. Okay. Thank you. That's a good baseline. Okay. So I think we can start with employment contracts. Okay. So I know many times in organizations, so we have people who are on fixed term basis or fixed term contracts, and then we have the people who are on permanent basis. What's the difference between those two contracts, and like what are the provisions that should be there in your employment contract?
Okay, so let me take you a little bit back to the types of contracts that you can have. Let me classify it into three just broadly because you could have different things. There is a casual contract. So you can have someone that works as a casual. The purpose of a casual contract is someone that comes and does a job for you, and you expect that particular job will be done at the end of a specific period. Say, for example, I run a company and maybe I am doing trunking of, what are they called? Electricity lines, and maybe like putting up electricity in the building and changing some things, maybe masonry or whatnot. I can get someone on a casual contract to come and do that job. But I expect within a certain time frame, I will not need him on a permanent basis or on a long-term basis. Some people go ahead and engage their workers on casual contracts, even though these are not jobs that end over a specific period of time. But the danger with that is the law is very friendly to casual employers. So if you keep a casual employer for quite a long time and they expect to keep doing the same job and it recurs, then it can very easily be construed by the Employment Act or an employment court to be a permanent contract. So that's the danger around it. So the way a casual contract is made or is construed, you pay the employee, okay, let me not call them the employee, the casual worker, at the end of a specified period. You can say, I'll pay you a weekly wage, maybe a bi-weekly wage, or I can pay you a monthly wage. So then we go to a fixed term contract. What is a fixed term contract? A fixed term contract is a contract that you get into with an employee for a specific period of time. It can be 6 months, it can be 1 year, it can be 2 years, it can be 3 years, it can go even all the way up to 10 years. But you have to have a very specific timeline within which the period is ending. So a while back, there was a bit of controversy on when a fixed term contract ends, do you expect automatic rollover? And initially, the employment court used to say, you know what, yes, you have the right to legitimately expect a rollover of the contract because you've been working and they've not given you a notice. Now the employment court is moving away from that because it's saying, you know your contract is supposed to end on 31st of December. Why are you at work on the 1st of January? You did read your contract and you did know it was ending on the 31st of December.
So
then,
if
yes.
I've not gotten any communication from the HR
On the renewal,
yes, don't show up on
don't show up on first. Unless your HR writes to you and tells you come to work, then you can legitimately expect a renewal of the contract.
So if I don't show up on first, they can't say that I've absconded.
No, because your contract term has ended. Simemalizana. Exactly. And then now there's a permanent contract. A permanent contract is the contracts that allow you to work until your retirement age. So most of them are usually open-ended contract. Okay, for most millennials and young people, I know you work until you find a new job. But it's usually you work until it's presumed, yes, you'll work until retirement age. And for fixed term and permanent contracts, the job description is more recurrent. Like, you know, you'll do the same thing over and over and over, and there'll almost always be need for that role. So a lot of permanent contracts, maybe an example of on permanent contracts mostly would be government employees, because they presume those officers will be running for a specific period of time, or maybe in perpetuity. Now, fixed term contracts is maybe employers that have funded projects, NGOs, mostly charitable institutions that know maybe in the next 5 years I might not have funding. So it doesn't make sense for me to give you a permanent contract. If I give you a 4-year contract, if I'm winding up in the 5th year, then it's easier for me to get out of it. It makes sense for you.
That makes a lot of sense. Okay. Right. So we've now seen, so what does the different types of contracts that you can get into. So before we move to the next question, on the casual workers. So for example, I know a lot of factories usually use casual workers. How can they, for example, protect themselves from like the labor court when it comes to the casual workers?
Okay, so you know the casual workers, they don't enjoy the same benefits as permanent employees, because casual contracts more often than not will last for a period of 0 to 3 months. So if your contract is a bit over 3 months, then it's safer for an employer to give you a fixed term contract. And that I'm speaking from an employer's perspective. If you came to me and told me I have this casual, I want to engage them for a period of more than 3 months, I'd tell you, don't call them a casual, call them an independent contractor. And alleviate yourself from the risk of the Employment and Labor Relations Court. Let them work for you as an independent contractor, let them pay their own taxes and all that. But then coming back to your question on casual laborers. Now, the office of the labor, I think it's called the Labor Relations Office. There's in every county and in every town there's a labor relations officer. And this labor relations officer actually are usually very salty when they find out that you have gone against the laws in relation to casual laborers and the employees that are paid minimum wage. Or maybe I need to explain what minimum wage is. So there's something called the minimum wage order. So the minimum wage order kind of determines in every town what is the minimum amount you can pay people. So it will talk about security guards, it will talk about cleaners, it will talk about domestic workers, just the people that the society tends to underpay. There's usually like a minimum wage that you can pay them. And more often than not, it changes. I think it's every year or every 2 years. So you'll find that maybe they say for someone that is staying in Nairobi and they're maybe a domestic worker, the least you can pay them is 15,000 maybe and 40. I think the amount might have increased. But the last time it was around 15,040. You'll know like a cleaner is supposed to be paid this much, this much, this much. So the Labor Relations Office actually usually has a lot of scrutiny when it comes to those employees and casual laborers. So that is one avenue to go as a casual laborer when you feel like you're being shortchanged by your employer.
Okay. Because I think, okay, since coming from an employer's point of view, I think I like the fact that the legal framework for Kenya has the different minimum wages for different counties. Because, for example, if you own a cleaning company, the amount of money you'll be paid in Nairobi is not the same as you'll be paid in Nakuru. So you can't be expected to pay the cleaner in Nakuru the same amount of money you're paying the cleaner in Nairobi. Yes. Because even the living standards are very different. Yes. Okay, that makes a lot of sense. So now let's get into you are being onboarded. Okay. So when you're onboarded into a company, a lot of companies put you on probation. So first of all, is probation provided for in law?
Yes.
It is?
It is provided for in law. So you are a very high performing employee. Why are you worried about probation? Should I be worried? Is there something I don't know?
I have not changed. I work very hard.
Okay, so yes, so probation is provided for under the law. I can't tell you the exact section, but it's provided. I know for a fact it's provided for under the law. So the maximum number of months someone can be on probation is 6 months with an extension of the same. So the thing about my understanding of the writers, so
that's how you can find someone had been on probation for 1 year.
Exactly.
So after the 6 months, probably the employer decided to extend.
Exactly, to extend your probation based off of your performance and based off of whether or not you fit well into the company. So there's different things, there's different reasons why your probation might be extended. Most people think it's just performance. It's not. One of the things employers need to look at is if you're the right fit for the organization. Sometimes you get into some organization and feel like their cultural values do not align with mine. What I believe in does not align with this. And the problem with us is we look at probation from just an employer's point of view. Even for you, the employee, you can decide, by the way, after 14 days, I'm gone.
Yeah.
Because this does not align with what I want. So it's for both of you. For both of you to assess the suitability of the relationship. So smart companies, and I'm saying smart companies, I hope yours is smart. So smart companies put the probation period for mid-level, maybe a little bit of senior management and lower cadre employees at 3 months, which is a very good practice, because after 3 months you can already gauge whether someone is a good fit. Then another extension of 3 months. You can't, if you're on probation for a period of 1 year, honestly, you as the employee might be the problem. And at that point, they say if you finish probation after 6 months and it's been extended for a certain period of time, at the end of that probation, you're either separating from your employer or you're getting confirmed. I usually say you can't be on probation for perpetuity.
Yeah.
In fact, you can't be on probation more than once. You go on probation, they extend the probation. If we see you're not working, out. Like, that is the simplest way to handle it. Yeah, but you're supposed to, before the current probation period ends, I'm supposed to notify you and tell you your performance has been below par, and then I'm going to extend your probation. If I do not do that, if it lapses even by a day, that lapse, even if it's 2 hours, gives the employee the right to say, me sikuambiwa anything, so I am now confirmed as an employee.
Oh, by the way, if they keep quiet.
If they keep quiet, you will confirmed.
You assume that you're confirmed.
Confirmed.
Okay, that's interesting.
You seem like you like that.
Oh, well, I think it's not necessarily for myself, because of course I think, as you know, for me being a compliance specialist, people assume that we have some legal background.
Oh, okay.
So, I get a lot of questions, like, from different people, like, in the different organizations I've worked in. People come and ask, okay, my probation was supposed to end this time. They've not said anything. What's that supposed to mean?
Tell them you're confirmed.
That's the thing.
You're confirmed.
Okay, I also don't want to cross my employer because I like my 29. So
like
I'll just keep quiet.
Maybe ulize HR.
Uliza to HR. My default answer is uliza to HR. I like my 29. Thank you. But anyway, it's good to know. I think there's some of these things that when it comes to employment, that we don't usually know or realize. I think that was something that, and that there was a time we were talking about it on social media, on Instagram, that when it comes to employment, people don't think about employment as a business transaction. Because you as an employee, you're offering this company a service.
Yes.
So as you're offering this company a service, they're supposed to pay you for that service that you're offering them. So just the same way, a company can decide to terminate a contract with a client. You yourself as an employee, you can decide,
I don't want. Yes, and that's what we do when we resign and go to other jobs.
Exactly. Yeah. So it's also important to remember that this is a business transaction. The company, the reason why the company has you there is because they need you to be able to fulfill their contracts with their clients.
With their clients, yes.
Yes. So this whole business transaction, I think, anyway, that's a story for another day. When it comes to issues to do with employment, I think you've seen on social media, people are making a lot of memes and TikTok videos about toxic workplaces and and some of the things they go through with managers who are incompetent or toxic. So on that note, I got a question from Stan.
Please ask. Help Stan out, please.
So Stan asked, so for example, if I woke up in the morning, I was trying to get to work, and I was stopped by the snow. Mystery Stan alitoa wapi snow?
Hata mimi I'm wondering that question. Hiyo swali imenisumbua kusema, imenipea changamoto. Imenipea changamoto sana hiyo swali.
So there was a giant blizzard. You couldn't get to the office because of the snow. And your employer decides to terminate your contract, saying that you absconded work. How do you handle such a situation?
Bring that file to my office. Okay, so there's some very basic rights that accompany the right to fair labor practices. I'm supposed to give you a conducive environment to work. And one of these things to do with conducive environment is I should know whether there's a snow, or you should tell me, by the way, on the road there was a snow, and I need to be able to understand. The mitigating factor there would be you tell me, hey, by the way, because you're not coming into work today, let me take a day off your leave day, or in these hybrid days, work from home.
Yes.
That's a better way of handling it. But then I know there are rogue employers that will decide, because you haven't come to work on this day, you have absconded. But then also remember, absconding is is quote unquote a terminable offense. So how many days have I absconded? 1. Have you taken me through the disciplinary process? Have you given me a notice to show cause why I didn't come to work or why I have absconded? Have I responded to it? Have you given me a notice of disciplinary hearing? Have you conducted a disciplinary hearing for me? Have the notes been shared? Have the minutes been shared? Have you made a decision to terminate? Have you given me sufficient notice if need be? Or if not given me notice if need be? If you've not given me sufficient notice, have you paid me in lieu of my notice? Or alternatively, if it's a what is it called? For gross misconduct, it's called summary dismissal or termination. Have you explained that clearly? Have I gone through that process? If I have not gone through that process, then the employment and labor relations judges will be looking at you like this, waiting to slap you with 12 months worth of Stan's salary. Yeah.
Okay, that's quite interesting. Okay. So I think also when it comes to employment, something that I'm picking out, you also need to have full disclosure or proper communication with your employer. Because unless you're working for a tyrant, I think most employers understand. Okay. So if you've gotten an emergency, just call. Tell the person, hi, I'm not able to make it to the office this morning because I got 1, 2, 3 emergency. Or I've tried to make it to the office, and I've gotten roadblocks on my way. And in this age of social media and where the media is very quick to announce things, they can also be able to verify that and see, oh, by the way, area X, there was a roadblock. Guys couldn't be able to access maybe the CBD from
like the times for floods in Rongai.
I know you get, I think, and it's also important for employers to be reasonable. Yeah, don't I feel like also sometimes someone has an emergency and you say, okay, sawa, tuta deduct leave day. I think that also sometimes doesn't sit very well
with employees.
So you also need to strike a balance if you're an employer to be humane, and also as an employee you also need to try your very best to communicate openly with your employer, and don't lie. You know that remember that video for this year you died twice.
Yes.
you were resuscitated 4 times. You don't be that employee,
Yeah.
I think if you're good and honest, I think an employer will
try and understand.
Yes, exactly. All right, so there's something you mentioned about disciplinary process. So sometimes people violate company policies, whether written or unwritten. Yeah. So, and they go through a disciplinary process, whether to determine whether they will be kept in the organization or put under a probation period or a performance improvement period, or terminated, So, first of all, tell us, what are the provisions of the law when it comes to the disciplinary process?
Okay. So the disciplinary process is a bit wide, and that might need maybe 5 episodes to talk about. But let me take a quick overview of it. So you said I have violated a policy. Now, sometimes those violations go directly into the law and into things that go into gross misconduct, like maybe being accused of things like theft, the entire gross misconduct list. That calls for, both of them call for a disciplinary action. But then again, you're supposed, when you're conducting the disciplinary hearing or taking someone through the disciplinary action, you look at it from which policy have they violated. Say, for example, it's a conflict of interest policy. What does your policy say are the ramifications for violating that policy? And apply those consequences to this employee. And how does this disciplinary process look like? For everything, it looks the same. Tell me, Mihala, there's this policy and there's this law and there's this that you violated. I am writing for you, and I'm writing to you and asking you to show cause why disciplinary action should not be issued against you. Then I can show cause, and disciplinary action will not be issued against me. Or I can fail to show cause, and then you send me a notice of disciplinary hearing. You can constitute a disciplinary panel, which you should have a person that is my peer. You can have your legal department there. You can have your HR department there. You can have someone in maybe like some level of management, but you have to make sure there's a peer of mine. Number 2, you have to make sure you explain to me that I can bring someone to the disciplinary hearing who can just sit. Most of the time they don't ask questions, they just sit. And when we get into that disciplinary hearing, I am allowed to ask all questions that I want to as an employee. You are allowed to ask all questions that you need to as an employer. You can substantiate your claims in that disciplinary hearing, or I can refute the claims in that disciplinary hearing. After that hearing, as a responsible employer, you make sure you minute everything and send those minutes to the employee and say, confirm these are the minutes of what happened. And then the disciplinary panel sits and makes a decision. They might make a decision to take me back to work, which then they write to me and tell me go back to work. They might make a decision to terminate me. And when they make the decision to terminate me, they write to me a letter and say, by the way, Mihala, we've made a decision to terminate you. You have 7 days, you can challenge this decision and you can file for an appeal. If after 7 days I haven't, they send me my final termination letter, or I consider myself terminated. But then again, I can appeal. When I appeal, the same thing with the disciplinary hearing happens. You call me for a hearing, constitute a panel, a fair panel, listen to me, I listen to you, deliberations, make a decision, either terminate me or keep me in the organization. And the thing about this disciplinary process is you cannot miss a step. There's a common mistake that employers make where they band the notice of disciplinary hearing and the notice to show cause together. Very wrong. Because if you band a notice to show cause is a letter that tells you you've been accused of stealing in the company. Okay. Please explain why we should not do disciplinary action for you because you've stolen. That one umelewa, eh? Yes. Notice of disciplinary hearing is come now and explain. So when you send me a notice to show cause and it says, come and tell me, please tell us why disciplinary action should not be issued against you. You can write to me and say, by the way, I didn't steal. That stuff is under the table on Danu's desk. Go and check. You go find, release me. So you see how there can be an imputation of bad faith if you band those two together. Yeah. Why are you calling me to come and explain, to come for disciplinary action in the hearing, yet I've not even finished explaining? Yes.
So there should be like there should be steps
Yes.
when it comes to disciplinary.
Yes.
So the first step should be the show cause. Then the second step, if in the show cause they still feel that there is a reason to take disciplinary action against me, then now it goes to the hearing.
Yes.
Okay. So what about summary dismissal?
Okay, so summary dismissal. Now, funny enough, summary dismissal, you still have to go through the same process. You still have to go through what courts have done nowadays is you said I am if you're accusing me of gross misconduct or underperformance.
Yeah.
Call me, substantiate, terminate me. It's the same process.
I can't just be slapped with a letter on my desk at you. Summary dismissal.
No. No.
Okay.
No. The only thing that is, I don't even know if this is the right thing. The only thing that is summary dismissal about it is the fact that there are very specific heavy crimes that now come, crimes quote unquote, that come with summary dismissal. And when you look at a lot of HR policies, they'll show you like these are kind of the soft offenses, these are the mid offenses, these are the hard offenses. Yeah. So they tell you maybe for the soft offenses you'll get a level 1 or level 2 warning or a verbal warning. Second, maybe level 2 and level 3, then misconduct, then you're terminated.
Okay, that makes a lot of sense because I think probably with summary dismissal, it has to be like a crime that you've committed.
Yes, not even like a crime per se, something that is so gross that we cannot keep you in the company.
Yeah.
Sometimes it's not really, even performance is gross misconduct. You expect me to perform at 100%. You're literally here for 8 hours, you only do this job. Your employer is legitimately supposed to expect that you do it and you do it well. If you're not doing it well, I put you on a performance improvement plan, you don't improve, I terminate your services.
Okay. Now you know, guys. Okay. All right, so we've talked about the disciplinary process. Okay. I think let's dial it back to things that are a bit lighter.
Okay.
Away from disciplinary and whatnot.
Maybe I got a little passionate, I'm sorry. Let's continue.
Wow, okay, yes. Okay, maybe before we dial it back, now that you've said you got a little bit passionate, I've just remembered something. So, for example, what if I resign from a company because I felt that my employer was harassing me? Harass can be of any form, can be verbal abuse, can be calling me incompetent. You know, there are those people who just walk to your desk and just tell you, you're very incompetent. What do you do?
What do you do? You never do anything in this office.
Yeah, no. Yeah. So what if I left a job because I felt that my employer was harassing me? Is there a way that either the Labor Relations Office or the Employment Court can be able to assist me?
Okay, so let's start with the best time to go into the Labor Relations Office, in my opinion. The best time to go there is when you're still with your employer, because they can compel your employer to do things when you're still in. Because also employers are very scared of the Labor Relations Office. They are, you remember the way our company was scared of the regulator?
Yes.
It's the same thing. But now when you talk about what you're talking about is called constructive dismissal. So constructive dismissal is a situation where I feel a little bit like I am being victimized, I am being harassed, I am not comfortable in this workplace, and it's quite evident that this employer or this boss doesn't want me. Sometimes it can even extend to sexual harassment, and I feel like I cannot report this to anyone, or maybe I've reported to HR, nothing is being done, things like that. So the thing about constructive dismissal is you leave, you resign, though you're saying you resign, and then you go to the Employment and Labor Relations Court. The challenge with it is you have to substantiate what the claims that you're making. So you can say maybe the other employees are being told to submit their reports on 12th. I was being told to submit mine on 5th. They were being given preferential treatment, and then this boss used to abuse me, and these are the texts, these are the messages, sexual harassment, these are the messages, these are the texts. So obviously this was not a conducive environment for me. And remember, one of the rights that you have as an employee, actually one of the basic rights of employment, is the employer is supposed to give you a conducive working environment. So if you're not giving me a conducive working environment, 1, you're violating my right. 2, if we're in the same job cadre with other people and they're not being asked to do the same things I'm doing, there's an element of discrimination. And then if I can substantiate my frustration, that becomes constructive dismissal, and the Employment and Labor Relations Court can award you damages for that.
Okay, Gen Z mumesikia.
I know.
The employer needs to give you a conducive work environment.
You know, let me tell you, there's something about the employment laws that people don't get. They're this, let me call them like soft rights. That's the best word I can use, that are not really hard put in the employment and labor relations law. Like, you know, I need to have a good working environment. Number two, in fact, even water. Your employer is supposed to give you water in the office, clean water for drinking. That one is enshrined, like it's basic. It's not even soft. And then the other one that people look...
I'm getting scared when I just get a text, the man is telling you, maji ya kukunywa imeisha. You're like,
yes.
Mr. Rider,
yes.
Chemsha ya tap.
Yes. They're supposed to give her access to clean water where they can be able to like drink.
Yes.
Then there is also the right of lactating mothers, where you're supposed to give them a nursing room and a storage facility in the nursing room, and you're supposed to allow them during working hours to go and express and like get their milk. Yes.
I wish I knew that when I was new mom. I feel like I used to be very scared of leaving my desk, going to go
express. No, you actually have a right.
No, because I used to try and go when it's almost lunchtime so that I don't offend the boss. That's a good...
It's actually a right.
It's actually a right.
Yes, it's your right.
That's good to know. Yeah, okay. So moms, now you know, please give people clean drinking water.
Clean drinking water. For God's sake, get a lactation room in your employment premises.
Yes.
Like,
you can't be having moms going to express in the washroom.
In the toilet.
As that's so, and it's very unsanitary for them.
Exactly.
Yeah. Okay. So now let's talk about money.
Money. I said I do this when I talk about money. Money. Tell me.
Hey, concern me. Yesterday I was scratching my hand. I feel like money is about to...
Please, your company is showing.
Just chill. Okay. I was the one interviewing. Please. Okay. So when it comes to money, so the first thing I think, ever since I got into employment, I found very funny is there's this like it's not a written rule that your salary is a secret.
Hey,
is that anything that is enshrined in law?
No. So what the law says about money is your employer is supposed to pay you a salary.
Yes.
However, as long as it's not below minimum wage, whatever you negotiate, that's between you and your God. Because in some instances, your salary is supposed to cover your housing, your medical, and whatnot. I think those should be things that we know by now. But it's not really enshrined somewhere in the law that you do not discuss your salary. In fact, nowadays it's highly encouraged that you discuss your salary so that you know who is being oppressed in the office. And that is not even a legal requirement. That is common sense.
That is common sense.
That is common sense. If you can be open about how much you're getting to your peers and put in a job level, then you can be able to actually substantiate you're asking for a raise, because then it becomes very easy for you to raise the issue of discrimination. Like, we're doing the same job.
Yeah.
How come you're treating me different? Article 27 is in danger here. Yeah. Is this a fair labor practice?
That's a good point, because I think one of the things that I've noticed is so probably a company has a certain has job bands, okay? And of course, many companies don't like to disclose. I think the only people who are very open with the job bands is government.
Yes.
Please, I'm paying you 50,000.
We're paying you 2,000.
Job group X, take it or leave it. I think the government and some of the international organizations are the ones who are normally open about their job groups. Okay, so for example, you find probably I came from a company where I was earning 30,000, and the job I've gone for, according to the job band for the new employer, that job band is 100 to 150,000, but my new employer sees, you are getting 20,000, so they just give me 50 because it's a bit of an increment. Can that constitute discrimination?
That depends with how you look at it, but I would affirmatively say yes, because if I'm in the same job description as you, let's say 6 legal officers sit here, all of us do the same claims, all of us do the same job every day. Each of them should be remunerated the same. Now, the challenge is the employer can come and tell you, but then remember, you're on contract. You negotiated this rate yourself. So whatever we are giving you is actually what you negotiated. But the good thing about the discrimination is, as long as you can be able to demonstrate and say, "Ndanu pay slip yako, give me your pay slip, take to the labor office and tell the labor office, by the angalieni, this is what is happening."
And unfortunately, I think one of the things employers thrive on is the fact that since we like our 29th and we don't want to lose our 29th,
you will not give your salary.
Yes, we will not give our pay
or pay slips
for someone to go and use as evidence that they are being discriminated.
Yeah.
Anyway, those are unfortunate bits of life. All right. Okay. So maybe as we are gearing to wrap up our episode, maybe you can tell us about leave.
Yes. Now, yes, there are different forms of leave. So there's annual leave, which is 21 days, according to the Employment Act. I was about to say constitutionally. That would be a lie. According to the Employment Act, leave is 21 days.
Okay.
There's sick leave. Now, the Employment Act says you have 15 days of sick leave without pay, 15 days on 15 days of sick leave with full pay, 15 with half pay. But there's again another general wage order. So that general wage order that follows the Labour Institution Act places that number of days to 30 days. So 30 days on full pay, 15 days on half pay. Now, there's always an assumption that if you say 30 days of sick leave on full pay, 15 on half pay, those days need to run concurrently. So it's 45 consecutive days. It's not. It can be, you can pick the days the way you want. But the thing about sick leave is not like annual leave where you just say, I'm going and you go. And even maybe I'll come back to that. Sick leave is you have to give a certificate from a medical professional to show that you are actually unwell. That's what earns you the right to sick leave. Now, annual leave is supposed to be prorated at the rate of 21 divided by 12. I don't know that math.
1.75.
Yes, that math. So maybe you can have like 2 leave days a month, but you can agree with your employer to maybe put those leave days together or spread them out the way you deem it fit. And an employer cannot rightly deny you leave. They cannot say you can't go for leave. They can give you alternative days and you have to consent to those alternative days. But also on the flip side, you do realize that it might look like insubordination if you just wake up and go.
Yes.
That is why a lot of employers have curbed that by having a system. I apply for leave in the system, you approve, I go. That is easier. Then we go to maternity leave. Maternity leave is how many months?
3 months.
Yes, 3 months on full pay after the birth of your child. Now, some employers have extended it. I think I recently saw like EABL has extended theirs to like 5 or 6 months. I can't remember the timings, but some employers have a bit of a longer time. And then there's paternity leave. Now, I was reading something interesting about paternity leave the other day. So maternity leave, the way this judge had put it was something along the lines of, like for maternity leave, for most women, you can always see that the woman is pregnant. So everyone is a witness to you asking for paternity leave.
Exactly.
For paternity leave, it's not the same. So there are people who are actually denied paternity leave. Why?
Oh, no.
Because you have, first of all, you have to apply. And it has to be written. And you have to substantiate that the child is yours. So either you give a notification of birth, and then you give a birth certificate. You can give a notification of birth in the meantime, and then when you get the birth certificate, you come and deposit it with the employer, and then that is even after you've already taken the paternity leave. So that's the challenge around paternity leave. And then there is
so before you moved on from paternity leave, so I've met some people who say that their employer doesn't allow them to go on paternity leave if they've not brought the birth certificate. And as you know, what you get immediately is the birth notification. The birth certificate, you may get it after almost 3 months. Is that fair, first of all? And what can you do about it? Because if you're going to give me the paternity leave after 3 months,
it's
my
no
wife
way
is
to
already
assist.
going back
Exactly.
to work. Like, it really doesn't make sense.
So a lot of employers actually should accept the notification of birth, but that is subject upon you bringing the birth certificate. So if your employer feels like hautamletea birth certificate, they'll not grant you the paternity leave. But when you look at how courts construe it, they're like, you didn't bring proof of birth. In fact, some of the courts say notification of birth is not proof of.
So now, what are we supposed to
actually
do?
some judges say that. Like I was reading that judgment, I think this was yesterday actually, and I was like, okay.
Tano sirudi employment.
Keep, lakini watu wenye wako self-employed wanachukua paternity leave. Wata apply wapi?
Tukitaka kushoot na stand akona mtoto wa wate. Tutaki kujua. We need to shoot.
So we spoke about annual leave, maternity leave, paternity leave, sick leave. Is there any other form of leave really? There's usually bereavement leave, but that's upon like the employer to give you. It's not in statute. Yes. Yeah. So in employment, we like to put them in two ways. Okay, maybe I like to put them in two ways. There are things that are benefits and there are things that are entitlements.
Yeah.
So entitlements are what the law provides for you: your salary, your 21 leave days, your sick leave, your paternity leave, your maternity leave, the right to be given a contract by your employer and you to understand the contract, the right to rest at least one day, fair labor practices, water, all those. Then entitlements now will be, instead of giving you 3 months, there's another 3 more months for maternity leave, which gives you 6 months. So the 3 months is...
That's not entitlement,
that's a benefit. Yes.
Okay.
Bereavement leave, benefit. Compassionate leave, benefit. Pension, that is not NSSF, benefit.
Okay.
Medical cover, that is not NHIF or SHIF, benefit. Maybe a cost of living adjustment allowance, benefit. What else can employers usually give you? Maybe they say you work 1 less hour, benefit. So these are things that an employer can actually take away. And most of these benefits are usually written now in your policy. So your policy will bring out the benefits. The Employment Act will give you an overview of what the rights are and the parameters around it. But your human resource policy will extrapolate those rights and get into the purview of benefits.
So as you've seen, that's why it's important for you to read your company policy so that you know what benefits and what entitlements you have. Okay. I think that was a very good episode, and I think we can wrap it up on the difference between the benefits and the entitlements. That's quite interesting. I think it's good to know what rights you have as an employee. It's also important for employers to educate themselves on what does the law require of them when they have employees. I think as we wrap it up, because here we talk about regulations, it's also important to know that there's a regulatory body called the National Employment Authority. Yes. And you're expected to, as an employer, to file returns.
Then yes.
Yes. Every year you file returns with the number of employees and the list of those employees that you had as at 31st of December. Yeah. It's not an authority that has been there for very long, but basically it's there to just help you to oversee how employers are being treated by their employees. Yes. And then of course there's the Federation of Kenyan Employers.
Yes.
That is for the employers, not for the employees. So that is like an association that gives the employers some knowledge on how do we handle 1, 2, 3 issue.
And guidelines, and they also have a good team of lawyers. Actually, they have a good team of lawyers that actually talk to employers on and off about how things should be handled. Take for example the housing levy. They issued a directive, and actually employers will follow more the FKE directive based off of the court order. So they know this month you're supposed to deduct, this month you will not deduct, and ABCDE.
Good to know. I think they even normally say they even send, in as much as public holidays are gazetted, they also send a notice to employers that this day is a public holiday. Give your staff time off.
Yeah.
Okay.
Oh yeah, also public holidays, being on leave on being away from work on public holidays is an entitlement. It is an entitlement. If you have your person at work on public holidays, ding ding danu, you're supposed to compensate.
This episode, by the way,
we have that discussion
of
yeah. Okay, guys. I think this was instructive.
Yes, it was a very interesting episode. If you would like us to talk more about the employment laws, what you don't know about when it comes to your rights, ask some questions. You can ask the questions on the comment section, or you can also chat us on our Instagram page at The Rundown. Okay, so it's been fun. As I had mentioned, my name is Ndanu Nzyuko.
And I am Mihala Barasa. Like, share, subscribe, and until we see you next time, bye.